I mean, pardon to make a mention.
Yes, sir.
Item number 46 in orders.
Item number 2.
Item number 40.
With respect to whether the order 47 to 7 of CPC is barred to file intra-court writ appeal against the return.
There is a defect. Why you are not removing the defect? Oh, how appeal? Yes.
It's well developed.
There is a how appeal line.
My respectful submission is the writ is filed under Article 226. The writ petition is filed under Article 226. And CPC is specifically not applicable to it.
Specifically.
CPC is not applicable to it. And secondly, if any provision of CPC is there say review, it guides the factor of review only. It doesn't apply to the judgment passed in the writ.
What is the rule here?
47(7) only precludes me from filing an appeal against the review order. I am not filing an appeal against the review order. I am filing
Appeal is maintainable against the review order, provided the review application is allowed. It is not applicable when it is dismissed. By that event, you will have to challenge both the orders. That is what is not.
my review order which does not decide it on merit.
So it is definitely, sir, and visualize, when a review application is dismissed, it does not invite a merger of the original order into a review order. If it is allowed, then it will invite a merger of the order.
The merger principle.
That's why the legislatures have provided a forum for an appeal, because the original order has merged into a reviewed order.
Exactly. Well,
That's
deciding it.
then the dismissal does not, then will you not challenge the parent order?
The principle of the merger apply only when the appeal order is original order merges with the appellate
It all
order.
depends.
But in case of review, my lord,
No.
the
sir,
review order
that's
merges
a
with
difference of
the
respect.
original.
It is not a universal rule.
My lord, there is
It
absolutely
depends upon.
nowhere divided.
It depends upon the exercise of jurisdiction by a higher forum.
My lord,
It never invites a merger in all conceivable situations. It is all dependent upon the nature of the jurisdiction exercised by the appellate court. Or a higher forum. Never. That's why I am asking you, sir, why? Because I am stuck with my own judgment.
my maybe given the response of the judge so that I can identify to
What
you
purpose? I'm quoting this provision of 47, rule, order 47, rule 7.
if a judgment
Sir,
is passed by
recently, in this division following Supreme Court judgment, they have said that the review principles are applicable to red jurisdiction.
review principle
Red jurisdiction.
applicable to
And a red person, while disposing of, while sitting and review against brief order, the CPC principles will apply. What is possible?
Sir, I tell you very frankly, previously there was a debate way back in 1900 and late 50s, whether the Red Court enjoins the inherent powers to review its judgment. The apex court says that it is ingrained into a Red Court. It can review its order. No problem. But the thing was that the procedure to be adopted. Review means they will ignore any principles and then review its order. That was not done. Ashok Rupahura case. That the constitution, this is another Supreme Court. They said under what circumstances review. Tungabhadra is 1960s judgment. Talks about what the review, how it should be dealt with. Tumda Bhakra is the, I say, foundational judge of the Supreme Court. All these things have been there, the procedures which are there. The only thing is, procedure is one aspect. Substantive right to review is another aspect. To review, unless provided in the statute, one cannot. True. Now the question is, once the statute has created a blender, and I think our latest patent also says,
Our latest patent doesn't say anything.
even Article 226 rules will say mutatis mutandis applies. Now the question is whether it will apply.
As I understand, madam, subject to the law section 0, an objection has been raised by the office saying that an appeal is not maintainable in view of the bar under Article 47, Rule 7, 6. What I was discussing with my friend, he has filed the appeal. He has initially filed the petition and filed a review petition. That review petition was rejected. Therefore, the
May I interrupt for little? If you come to page 30, this review application, please.
Review appeal.
Your review petition. The nomenclature. The cost item.
Yes, yes,
Please.
yes. 114, 151. Right, to review the orders. Correct. No, I got on this. What your assessor saying, see?
That,
No, I am not certainly.
that,
No, I am.
now he's saying that he's not.
That's right. I'm certainly not supporting his submission.
No, it
Submission
is
to the
for
extent.
the better interest of the bar.
Right.
Advertial is what a better interest of the bar.
Right.
That what should be the correct proposition. We are
Right.
just thinking about the proposition of the
Quite correct.
not concerned with this.
That's right. What I am trying to submit is review application has been filed. That was rejected. Therefore, what is staring at the petitioner is the original order passed on the writ petition itself. So that is only to be challenged.
Chair,
So that has been challenged in appeal.
Both are.
no.
Not
May
both.
not.
If I challenge that, yeah, my lords are correct. If I challenge that review order, certainly it's not maintained. Therefore, his challenge is now confined only to the main.
Correct, doctor. He has to.
Right.
That is what
That's
I am
because the
asking.
discussion was going otherwise. I
Because,
just
because the
interfered.
consideration in the review application is very limited.
Quite limited. That's it.
Is an error apparent on the face of the record if it does not. There may be an erroneous order.
Correct.
But that does not mean it is an error apparent on the face of the record. You can get it corrected by the
Correct. Correct.
So they have to file an appeal against the original order.
Therefore, this appeal is only against the original order.
No,
Yes.
it is against the review order.
No. It's
I
only
have
against the
wrongly written it, I take it
He
back.
has deleted that. He has
They have deleted.
he has later realized and filed a petition to delete that
My-
prayer.
One IA I have.
Therefore, that
For
defect
deletion
will
of
be
that one.
a defect in the.
You realize the difficulty.
Now he has
Which
realized.
order you have annexed with the appeal?
Correct. That is what.
Now tell me, which order you have annexed with the appeal?
Both the orders I have given, but I.
Certified copy of both the orders?
Maybe pardon.
Again, there will be a problem. I am asking.
Maybe pardon
Have
to
you
withdraw
annexed
this
a
and
certified
I.
copy of both the orders?
He has given both the
Both the
orders.
orders I have.
But
given.
he is not.
Certified copy, I am just asking,
Certified.
which is one of the condition for appeal. Has he? Or only the certified copy of the review order?
No,
Uh,
both.
Show us, where is the certified copy of?
No, certified copy, my lord, I am having the certified copy.
Uh,
But I have given the copy. Yeah.
Again, there will be a second defect. Huh?
I have given the copy, but since the other copy was already applied before the review forum, therefore I have obtained another copy. and
Where is
given.
your memorandum
Kindly have a
of,
look at.
where is your memorandum of appeal?
My number.
Page 18 is the prayer.
No, there cannot be a prayer in the memorandum.
That's right.
Under Order 41, Rule 1 of the court, please look at it that what the memorandum should contain. An appeal is filed by virtue of by filing a memorandum, not an application.
That starts from page 1, madam. Memorandum of appeal challenging the judgment dated so and so passed in the honorable single judge in WPC case number so and so.
No, only review.
Right.
I have deleted that part in my petition.
No, then it will not be. Challenging a judgment dated 22nd of November
Well,
passed by the Honorable Single Judge in WC number such and such. Oh, both. And the order dated 10/9 passed in review.
That person has filed a petition to delete that.
one IA I have filed to delete it, madam. But as your lordship rightly said, the IA cannot be entertained without entertaining the tapin itself.
There is IA.
The IA number in the 4113 of 2025.
What?
4113 of 2025.
This is an application.
Only discussing with me, therefore this I had.
So there was a considerable debate on this point in another case. And ultimately it was found in a report section. So I was party to the judgment, so I said, I'm ready to admit my the error which I have committed. So when did you convince me that I have committed an error? Difficult. Yes.
Item number 3.
Thank you. Here the petition was the licensee of Austin liquor shop.
Oh, all right.
He has challenged your demand notice under Annexure 9.
What is
Yes,
nothing?
Lord.
Small amount.
No, Lord, it is 44 lakhs they have demanded for the period I was not licensee and I have not operated the shop.
Why?
Lord, they issued notice. They directed.
Why you did not operate?
Lord, because I said that they directed to deposit 5 months license fee at a store. So I filed an application stating that I am financial problem. I am also facing family problems. So I can't deposit. If I permitted month-wise, because it is in the middle of the year, they have directed.
What is the rule?
Lord, there is no rule in that regard. They have issued policy. On the basis of policy, they have issued a letter to me. So there they directed, they deposit 5 months license fee at a time. And Lord, they increase in the middle of the year, they increase the Mohapra license fee from 1680 to 1800. In those two grounds, I filed an application stating that in these circumstances, I will not take the license. So, Lord, they issued show cause notice. I submitted reply to show cause notice. And without considering, they issued demand notice. And on the demand notice, I also replied.
Show cause notice?
Yes,
Where is your reliance?
Lord, Annexure 6 is the show cause notice. At page, Lord, 31.
30?
Sorry. 33, Lord. Annexure 7.
Sorry, 34.
There are two show cause notice.
Okay.
Lord, they have issued, first one is 31/12 and another is 22/5/25. Both show cause notice I have submitted.
Just give. Okay. You find your reply.
Lord, I filed reply at page, Lord, 35. Annexure 8. Para 3, Lord,
Yes.
2 and 3 I have stated.
Is there any decision which has been taken by you?
Lord, no decision. They issued a demand notice.
No.
Then on receipt of demand notice, I submitted reply enclosing the judgment of this Honorable Court.
Second show cause
Lord, second show cause is
for non-renewal.
same, Lord, same language. Both are same language. Only they have stated the figures, the amount figures in the color.
Have you given reply to this?
Yes, Lord. That is the reply at page 36.
Yes.
Both the replies have not been considered in demand notice at page 37, Annexure 9. The statement state that consideration money for 7 months, September to March, as well as Mohapla utilization fee.
How can you do it, sir? When you have issued a show cause notice, then this you have to decide the show cause. Either say the plausible explanation is not satisfactory, reject that and proceed for the demand.
But I'll take instruction.
This instruction exercise is rampant, sir.
No, whether any order has been passed on the reply given by.
Yes,
You know-
they passed the order also.
Where?
Pursuant to demand notice, I submitted again reply.
No, I am talking about the show cause.
No, so cause no reply. I have stated.
What I'm asking.
Yes, Lord. Sir. There is no reply.
No reply. Against the demand also you have again.
Yes, Lord. I submitted reply enclosing the order of this Honorable Court, where this Honorable Court held that
Answer
if there is no license, there is no contract, so there is no liable. Lord, they passed an office order Also, that is not considering you are declared defaulter. Applying rule 35 and 149 too.
Because with the demand is founded upon the allegations made in the first notice.
Yes.
So once they have not decided.
Yes, sir. Of course. Demand goes. If demand goes also.
So that is what I am asking.
Yes, sir. Obliged.
When you file the writ petition and when you serve them.
No, I have filed on 12/9.
So.
12/9 it has been served.
And service.
Not service on same day. Otherwise, can't be filed. Number.
Because it is.
Well, since 3 months time has passed, for that your officer has not given you instruction.
This has actually not been conveyed to the officer. It has come for the first time. Yesterday I got the file. for the first time.
Why not a particular, I think the procedure should be adopted.
I'm aware of what
The
my
moment the service is affected upon you concerning a particular department, immediately approach the department, seek their response.
that
on the
practice is there in
allegations.
other high courts, but I'm
This is what, that is why I'm saying I'm groomed in that
Man, I am aware. Practice is
atmosphere
there.
where this to take instruction exercise is very rare. All are equipped with the instruction.
Man,
Otherwise, there won't be any point in maintaining LMS. LMS has been put in place since last 12 years, I think.
then not 12 years, but
yes,
it has
yes.
been there for a long time.
110 sir. I know. I was part of that.
Yes, man.
So,
In that High Court, the rule is that no writ petition would be listed for admission before 48 hours of the service of the copy of the writ petition. 48 hours, 2 of working days is given for the reason that in the meantime you can get the instruction.
That practice is
Is never rule 26 of the appellate side rules and the original side rules.
has to be inculcated in here, my lord. Just
It will be a farcical one because the once you are into such system for a long time, overnight you cannot change the mindset. That is the problem. It's a mindset.
and similar copy of similar order in respect of another person, dealer. Dealer.
Yes, yes, Lordship. I have enclosed that with my reply.
there is
And that also will not considered.
There is a slight difference in that order in the fact situations. my lord.
Sir, whatever the fact situation, we are setting aside the entire demand and directing you to consider the show cause, give them an opportunity and then pass the order. Yes. Whatever you want to pass. If he is a default, he is a default. There is no difficulty.
There cannot be, Lordship. The collector has stated in his office order that shop was closed from 1/9. No renewal. Lordship, at page 48 is last but one paragraph.
Man,
Once there is no renewal, there is no contract.
Yes, no contract.
That is last but 2-3 paragraphs.
Yes, ma'am.
in that case,
That is the issue.
there is a small difference. In that case, the petitioner had intimated that I do not intend to renew the license. He had given it in writing. But in this
The
case,
question is, again I'm saying, can you give me 2 cases having an identical facts? You will not find them.
man,
One
That
has
issue-
to call out the ratio of
Yes,
the
man.
law.
Lordship.
The ratio of the law is that if there was no renewal, whether the licensee intended to renew or not, if the authority sat over it, is it not wrong on the part of the authority? Can he reap his own wrong?
no, my lord,
Can he reap the benefit of his
no,
own
my lord,
wrong?
he cannot.
Can he take it? He sat over the application for renewal for 4 months. And
No,
then
the
he
petitioner
says
not-
that for this 4 months you'll have to pay.
my lord,
Is it
this-
justified?
The statute says, my lord, what the petitioner suggested that I will give every month I will deposit the fee. That is not permissible as per the statute.
That
My
you
lord,
have rejected.
we have issued.
You have not rejected. also.
Whatever
we have
be the
issued-
reason, that now the second larger issue is, if you have not issued any circular, if you have not issued any regulation, if you do not promulgate any rules, policy decision is your policy decision. Is it binding on them? Is it? you must show the source of the path.
But that is there in the statute itself.
I'm sure then this larger question will come.
Rather than
Like
section
whether
45
this
says
is a source of.
that it cannot be a right of claim. You cannot have a right of.
I mean, that is what I'm saying.
Actually.
So that these are the larger issues. We appreciate, but this cannot be done. Either you suppose if you have not issued a show cause, straight away demand. I can appreciate, no problem. Then you have said that for this period, I find that you have not paid. This is what the demand legally applicable. I'm asking you this demand to this. I can understand. You can definitely raise a demand, but once you show cause, issue a show cause, will you not accept?
Yes, Malas. To that, Malas, I have to bow down because they have admittedly not decided how to show. Malas may give liberty to the authorities to decide or take a decision and then proceed if they are found to be lacking in any manner.
Obviously.
Malas.
The challenge is made to the
The petitioner is a licensee in respect of IMFL offshore.
What shop?
Offshore.
IMFL or foreign liquor or a country liquor?
No, IMFL, Indian made foreign liquor.
Indian made,
Indian made.
not a foreign made.
A foreign made sometimes. He was allowed to run his shop on a market complex run by the municipality. So there was a direction 2024 by the Joint Commission to all superintendent across the state to verify the status where the shops were made functional. Subsequently, in course of inquiry, it came to the knowledge of the collector Sundargarh that the market building on which the petitioners were allowed to run his off shop is a constructed by the municipality on government land. So taking the recourse of Rule 20, Section 20, Rule 23(7) as embargo, no any excise shops are made functional over the government land. Then my shop was closed. I approached this honorable court. Then the direction also look at page 12, not annexure 2. The direction was my shop was allowed to open and license was renewed, but I will submit an application for shifting. The date was fixed. On the date fixed, I submitted 3 lakhs rupees the statutory fees for the shifting along with the applications and land particulars. Now, all of a sudden, after a lapse of almost 1 year, they have given direction that the impugn order at page 17, you shift your shop within 7 days. So,
To that place.
to the place where I have given.
You have.
Yeah, I have given the application.
Shift it.
But I will shift, but 7 days is very late.
What is this?
Because the entire, but it needs lot of time.
What
for
lot of time?
For electric.
For 1 year, 2 years.
No, but
So,
another aspect, Mela, there is an objection raised by the municipal authority, the chairperson, that annexer 17.
what? That you should not shift.
No, that is the objection.
That you should not shift.
Yes, they showed is that schedule
First
area,
year
the schedule area.
But
must
Lordship's order. Yes, it's local purchase. Date has been changed. Lordship's order.
we have to enforce it. We are just giving it where it is.
Yes. Yes, more than two, less than 2 quintals, there is no permit or pass required.
No transport cost is incurred by you.
Yes,
I think.
but they have limit.
So on that cannot be included in your.
Yes, yes.
Price.
22, 23 and 24, 25 there. Premises. So where is there is a transportation? So they are claiming for that you pay the transport.
This is the FOR.
Yes, Lord. And less than 2 quintals.
Already earlier.
Yes,
Supplier is supplying the goods at the destination point.
Yes, Lord.
And for the amount of the goods, the price of the goods includes the transportation charges. They did not have to bear any transportation. How can you impose anything on a transportation charge? There is nothing. He has not transported. It is delivered at his factory or whatever.
Yes, Lord. Where there is transportation, we are paying transportation fee. But here in this less than 2 quintals as per rule 4, it is not required.
Madam, there is a distinction between a tax and a fee.
Yes.
When you levy a fee, it must be in commensurate with the actual. But tax, you can definitely, there is no difficulty. So if there is no actual transportation, how can you charge the transportation?
Well, you've asked the department to reply to this, Your Lordship.
What is the reply? I do not know. There is the two matters have already been decided against you. Then why we are keeping this matter?
It's their excise policy which they need to revisit, Your Lordship. So we will
What?
ask them. the department.
This is not a policy, excise policy or
The
something.
policy is still continuing.
No, that is there. It's the factual distinction.
Yes, Your Lordship.
If there is actual transportation, they are liable to pay.
Yes.
If there is no transportation charges which he has paid, how can you charge a transportation fees on that?
It needs to be ascertained whether it has, those people have actually locally given them in that premises
given
or.
as well.
Is a cultivator of the flower.
Yes, Your Lordship.
After plucking the flower, is delivering that flower to his
This is premises.
premises, means the manufacturing unit. He is not paying any transportation. He is paying per flower this much of an amount, which includes the transportation by the cultivator.
Whether it is a cultivator who has
Please-
deposited those
please
flowers in his
certify-
premises or he is securing the flowers. The outside, Your Lordship, is a factual.
Yes, 35 last paragraph. Yes, 35 last
Yes, Your
paragraph.
Lordship.
You read it. From where you got this factual observation? As per provisions, so and so, and clarification, transport fee on any quantity of motor transported in each occasion, so and so, so and so. Market to storage godown,
Yes.
and from godown to distillation was to be levied from the outstanding licensee.
Yes, Your Lordship.
Right? This is the law. Then, however, it was noticed that during the year so and so, the transport on Mohawk was neither collected at the time of transportation of Mohawk from godown to distillation point, or nor collected on the quantity of Mohawk procured. Where is the fact? How could you notice? What is the basis?
This is,
What is the basis? From where you could come to notice? When he's saying in a positive sense, you are negativing. So where is the evidence?
If all those matters,
Yes,
if all those matters,
We give the list to them.
Ms. Satyan,
Tomorrow,
please take instructions, whatever, in any of the matters. We do not want to keep these matters for such. Passing an interim order that really creates an hindrance in you. So let us decide finally. So at least the clarity in you also will come, whether you can continue with this or not. So give me.
I'll give
the numbers
Yes.
to, that
Yes,
is to her
tomorrow.
also. Talk to them, both of you talk, give me a date, we will fix that matter for hearing and disposal.
Yes.
Policies.
Yes, sir.
December, we have
Policies.
fixed the date,
Yes.
all these matters, please,
Yes.
get, we'll keep these matters also. But that you would take a charge and then if you want to argue, you argue, or anybody else, you want to engage, we have sufficient time. It's 12 December.
Before the 11th.
Okay, 11. Keep it on 11.
11th.
Let's call the case.
Item number 6.
Connected cell.
Name.
Item 5, there is connected.
Item 5, both the matters.
That's two, 6.
Item 6, sir.
This is regarding lifting of 180 ml.
This is also I want.
My lord, I was assessed for the period 17-18. I went in appeal. It was rejected on the ground of delay. Then I came before this honorable court. And this honorable court, in a coordinate bench, where my lord Justice Raman was also a party to it, in notification now referring to notification number 53 of 2023, my lords directed to remit the matter to the appellate authorities to hear the matter on its merit. I went before the appellate authority and filed the.
You are challenging the order of the authority.
My lord, it's a second round after the
Whatever,
direction.
after remand, whatever. Now it is a parent order of the appellate authority.
My lord,
Now the question is the further right of or a remedy is also provided to go to
my
the
lord,
tribunal.
my lord, it is there. But
It is there. So go to the tribunal.
my
Now
lord, the
they have come
previous
up with the notification.
no, lordship, there is a previous.
One 107. 1071. It was disposed of.
No.
It is second.
It is a second appeal. Yes, sir. Upon the
No, 2 years, 1 month, 1 day, delay. On that you have rejected.
Remains more than 2 years, 1 month, 1 day
So on that
is
basis.
beyond the period of limitation.
Because it is the second time appeal has been filed. What happened? He has a ground. He has a ground for adjudication. I don't dispute that. On the first round, he has filed against the first appeal rejection order. So in the meantime, there was a notification come by the CBIs. In that notification, it has been clarified that if 12.5% will be deposited, then the delay will be condoned. Pursuant to that, this honorable court has remanded the matter for consideration on merit, Your Lordship. That appeal is pending, Your Lordship. Subsequently, he has filed another appeal.
Against the same order.
Against the same order. He has filed another appeal. This is the rejection. This is the rejection order.
How it is maintainable?
Not maintainable. That is in Your
That
Lordship.
appeal is pending.
That
appeal is pending.
So I can file a second.
must be
again appeal.
Well, it was upon the direction of the first appellate authority. Appellate party number 3 might not have taken the awareness.
Sir, the right to appeal emanates from a statute or from an oral observation of the court. Tell me. It must be there in the statute. Can a court create a jurisdiction which is non-existent? Because the appellate authority say you file an appeal and you find an appeal. How? When original appeal against the original order is pending.
My lord, I bow down. But there is a technical issue which the appellate authority said that
What
the
technical issue?
portal would not be taking up that appeal.
So that does not mean now the ground of delay.
Well,
Just imagine. What is this appellate authority? If the portal is not functioning, that does not mean the appeal will be effaced from the file. If it is filed within the period of limitation.
So that is his government.
No, first appeal is pending. This is actually not a second appeal. It's a misnomer. It's a further appeal.
Second
It should be a further appeal.
further.
Page 24, this honorable court has remanded the matter. Page 24.
Remanded for.
Resto. Your Lordship.
None or the subsequent.
No, appellate authority. First appellate authority, a batch of petitions.
This is of amnesty.
Your Lordship.
My lord.
Amnesty scheme was there.
There's even amnesty scheme. Matter has been disposed of here and remanded. That matter, he could have produced that document, that this order before the appellate authority. Without producing that, he has filed a further appeal. Further appeal. So further appeal was rejected on the ground of delay. Admittedly, there was delay.
My lord, in both the appeals I have mentioned about the order of this honorable court.
It's not maintainable.
So both sides, there is mistake from both sides. It can be admitted, Your Lordship.
You know.
Page 20. The operative portion is at page 20.
24.
This honorable court has quoted the amnesty scheme.
So your original appeal
My lord,
was also dismissed.
yes, your lordship, that on the ground of delay. Okay, no, first
After
the
remand,
after
after
remand.
First original appeal, I am asking, because I look at paragraph 6, I am reading at page 24.
My lord, yes.
So I am just reading because it
Original.
they have settled
Original.
the entire matter and to proceed, the appellate authority to proceed in accordance with law. That means the appeal which are pending there.
Yes, your lord. It is
What order was set aside?
D.
delay.
That was rejected
On
in
the-
Annexure 2, page 16. Annexure 2, page 16 was the original.
There was no remand.
One zero seven four initial was revoked and appeals were rejected. So we tagged in one common argument.
But,
Relying on the amnesty,
Your Lordship,
we have restored the to the court.
my,
So they are pending. In the meantime, we have filed another amendment. With regard to challenging the same order
Same.
of
of that,
adjudication.
Your Lordship,
So that is 2 years and some odd bill.
Your Lordship,
My lord.
So this appeal is rejected,
Your Lordship,
but that appeal is still pending.
My lord.
Your Lordship, I think so.
Yes, your lordship.
You are not,
I'm
You
not
are
taking
So
stock.
that will create a problem. I'm telling you, this order, if we allow this to remain, it will create a problem.
two contradictory orders.
No, because that order is true, found us the moment the appellate court dismissed the setup. Mr. Mishra will advise.
No, appeals are different or what?
No, against the same order.
Same order.
order. Appeals are different.
Different,
Two
yes,
different, two different.
two different appeals.
Because Your Lordship, my Annexure 2 is the first rejection appeal order. Annexure 2, page 16 was the first rejection which has been restored by the Honorable Court. So that is the appeal number. Your appeal against
No,
ARN.
this is the original appeal was dismissed earlier.
Your
Yes,
Lordship,
your lord.
That was challenged in the written
My lord.
petition,
Yes.
and that was order was set aside.
Set aside.
Then why you went and filed a further appeal?
To my lord, directed to hear for the appellate officer to hear the matter on its merit. So we filed an appeal.
How can you? That is the advice you got. What is the effect of the word remand? Remand means what? There is already an existence of a thing, and that thing is restored and to be decided again. That's a remand. The existing thing is sent back to one authority to decide further appeal. Under what conception? The court in paragraph 6 does not say so to file a further appeal. Now you face the music. We will not interfere with this order and say correct. If it is beyond the period, then they have no authority to condone beyond a particular limit. What will happen? You face the music in that appeal.
But my
Face that music.
just as my one submission. My lord, may come to page 23. My lord, in that notification, where in the last paragraph, they have mentioned the said person shall file an appeal in April 0.
What was the situation? Situation was where no appeal was filed,
Not
this was given. Further, when the appeal is already there, then paragraph 6 is the ultimatum. It says, I am remanding the matter. You decided afresh on merit. Read paragraph 6 of the judgment. Very clear. What is the meaning of the word remand? Remand to the appellate authority to proceed with in accordance with the law. What is this? It's kind of a fuss. The SSE is suffering.
Original one was, my lord, filed on 31st of January 2023.
See you.
It has to be sent within 1 year. The time limit is given. 107. I know 107. It is being disposed of within 1 year from its institution. No, it will not matter. It will not matter. It will not matter. Just well, that would be good in the school of course. I don't think that's very mistake. No, Mr. doesn't have that story. Whether that other no, he cannot. Are you saying that? Yeah.
The first appeal, I mean the earlier appeal is pending.
That I have taken stock.
No, you also do not know. You will say that you have not received the notice. It is sent through mail.
Because your lordship also, he has one application, he has a right.
9 months is 1 year.
My lord,
Yes,
it's there 10713. The appellate authority shall, where it is possible to do so, hear and decide every appeal within a period of 1 year from the date on which it is filed.
And you filed in 2023. This is what my brother is asking. It should be disposed of by the end of 2024.
So this is dismissed and that is not proceeded with appropriately. Then another problem.
The problem would be If that appeal is still pending and he pursue, the department will take a very valid ground of defense. What we think is that this appeal was unwarranted and it is not maintainable. If the appeal is not maintainable, the question of condonation does not arise. It is only when it is maintainable but filed after a period of limitation, the question of condonation will come. But if the maintainability is at this state, then there's no, it has to be dismissed on the ground of non-maintainable. So that is what we are thinking.
Let's see, only but let me take instruction whether the original appeal which has been restored.
Secondly, if the original appeal has already been disposed of, then also this appeal is not maintainable, will be held by a principle of res judicata.
In fact, portal, when it is filed in portal, let's see, so tag both cannot be, may not be
So
tagged.
certain contingencies, if you do not provide in the software, will that denote his legitimate right of appeal?
Let's see, if there is any, what my submission.
Software or you have not provided for any contingency that may crop up while filing. So that will prevent him from expecting
No,
his,
further filing is not required. Pursuant to the Honorable High Court's order or amnesty
everything
scheme.
you have made it e-mode, but you have not given any scope for application of mandate.
That is not our control. My authorities control, that is GST.
The only thing is, can you take an instruction?
Yeah.
Just now take an instruction, tell you
Let's see,
whether that appeal, have you got the number?
Yes, Your Lordship. It's an
Give you
I'm
a
trying to consult.
just only ascertain whether it is pending or it has been disposed of. That's all, nothing more than that.
Your Lordship.
We do not want
I'm trying.
just keeping it part over. So create a mess for your client.
Time is about on. Time notes.
Yes.
Item number 8.
Annexure 2 proposed notice and Annexure 3 your lordship the final order. Since has not been brought to the knowledge of the present petitioner, appeal could not be filed within due time. They have only uploaded in the MLOD portal.
I have, rather we have,
Page 6, paragraph 7, your Lordship.
We have already.
we have taken a decision.
Page
You go
6.
through this judgment of ours.
Only your lordship, only lenient
Go through
Those are-
our judgment. Tell us that where we have committed wrong.
And he has admitted also. Here, the argument also at paragraph 7, page 6. That it is the petitioner most to submit the purported show cause notice and impugned order are only uploaded on the common portal, but neither has been served. And your
So
Lordship
this
has
is our
decided.
judgment. Look at it.
Yes, your lordship. I have seen it, your lordship.
What more?
Only your lordship.
Tell us that we are wrong in that.
No, no.
We are ready to correct ourselves. No,
Not
but you convince us that we are wrong.
Only your lordship, I will bring to your lordships to the section 169 again, your lordships. 169, they have, it has been the prescribed procedure of notice has been given.
Yes. Multiple,
Yes.
which
And
includes uploading as well.
yes, your lordship.
So,
Everything is on and all the 7.
so if one is exhausted, then what will be?
Yes, your lordship. That is the only thing is that, my lord, that whether only one point to be decided by your lordships, that when the first, it is the criteria as per the statute that the notice has to be served directly to the petitioner, and thereafter all the other procedures have been prescribed.
Where is the convention?
169, your lordship.
I'm
Service of
looking at it. Please show me.
my lord.
Where?
1, may placing this time.
Please.
Any decision, order, summons, notice, or other communication under this act or the rules made thereunder shall be sought by one by any one of the following
What is
methods.
the meaning of the word anyone?
Yes, Your Lordships. Alternative.
Then
The first one is that by giving or tendering it directly or by messaging including a courier to the addressee or the taxable person or to his manager or authorized representative or an advocate or a tax practitioner holding authority to appear in the proceeding on behalf of the taxable person or to person regularly employed by him in accordance in connection with the business or to any adult member of the family residing with the taxable person. And thereafter on the
the one word which is used after that.
By registering post, register
Before that, in clause A,
Uh,
you have
or
read up to taxable person.
Yes.
Thereafter,
There is a semicolon.
or
what is the meaning of word or?
Your Lordship, I do admit that all the procedure, everything has been prescribed, but Your Lordship has to only decide that if there are several procedures.
Where is the provision of containing the order of preference
Lord,
or order of precedent?
my only submission before Your Lordships, only as a mere, only uploading the
That is what
notice.
Statute provides.
It has to be
And
go
the
one
word-
by
and
one.
The word any of the following word, any means, if one has been exhausted, that's sufficient. That's sufficient. This is what we have.
That my Lord,
That is, we have
Only-
interpreted this word as the word or which is disjunctive in nature. It gives an alternatives or to run simultaneously. Any of them, if complied with, is a sufficient compliance in the system. That is what he heard. If you say we are wrong, we are
No,
ready to
no.
accept.
only I pray Your Lordships, only they may leniently consider my application so far as the statutory appeal may not only because
Is there any outer limit?
120 days only they are Your Lordships, 112
So
sections
are
are
you within that particular outer limit?
no, my Lord.
Can they condone the delay beyond the outer limit?
Lord, let them-
One judgment you show of any law. I'm giving you Arbitration and Conciliation Act section 34.
company
You go.
judgment.
If it can be done, I am ready. I'm giving you example of Commercial Courts Act. Order 8 Rule 1. If you go, tell me a judgment against it, I'm ready to accept.
Central Excise. Only for lenient consideration, Your Lordship may one word, Your Lordship may
When the power is curtailed, can an authority or a court exercise a power which is not there? I am asking a very simple question or a proposition or
Your Lordship may call this matter next week, Monday. I'll satisfy Your Lordships by
if you cannot, by a single judgment, if you could not come, then
I'll try my level best to
Then,
Your Lordships to come.
then something has to be added while dismissing the appeal.
Lord, I have already penalized by not filing the appeal. So I'll try my level best to my Lord get
Without-
something from the for the
Is
petitioner. my
there
Lord.
any extension, any amnesty scheme
No.
or something of that?
This no you. This is
Was it
this is covered by this judgment.
on an outer cap is given?
Only Monday, Your Lordship. Only Monday.
Nothing.
Because this is only also, my Lord, the another council is also there. That is why, my Lord,
What
only
also?
the engaged council is there, Your Lordship.
Sorry,
Your Lordship may call this matter.
Why you chose to take a risk?
My Lord, Your Lordship may call this matter on the next
No.
posting, Your Lordship. I'll try my level best. One day, Your Lordship, because I have the same order, Your Lordship may pass on the next day.
No.
Only, my Lord, I am praying.
So we are dictating the order. We will just put the date. So let us dictate the order. We'll put a date of that date.
Same order, because, my Lord,
No difficult. We'll do it. Unnecessarily, we don't want to keep them.
I have already deposited my 10% in advance.
I understand. They will refund it.
Only one date, your lordship. 7 days time. Next week, or your lordship may call this matter tomorrow. Even I'll tomorrow also.
Lot of judgments which are there against you.
I'll your lordship. On the next date only, I pray only 7 days, your lordship. Only 7 days to will.
No. We are dictating it, and you come after 7 days, you'll consider. We will not sign it. If we find that it is wrong, we'll recall. So don't. The yes.
Only with the liberty to work out my remedy, your lordship. Only with the liberty to work my remedy, your lordship. Only.
Is there any remedy available?
I'll try my, let them dismiss on that same ground, because I have not exact.
Because it is not in order.
Let it be taken up. If we take up, there is a difference. Yes, 9.
Item 9, sir.
Yes, sir. By filing this petition, the petitioner challenges the impugned order annexed to 6, that is the assessment order passed under section 147 being passed. The order has been passed without satisfying the judicial conditions prescribed therein. The order has been passed by the faceless assessing officer, whereas under section 148 has been passed pursued by the jurisdictional assessing officer, where there is no concurrent jurisdiction. Therefore, this without jurisdiction, since the statutory notice under section 148 has been issued. I have challenged the order in order under passed under section 147, you would issue upon section 144B as a notice under section 148. That is an exception. There's 32 of the petition. Notice has been issued the ITO 11 cutter, where the assessment order has been passed by the faceless assessing officer. Under the faceless scheme notified by the.
That would not follow.
Yes.
151A.
Yes, that 151A order.
The jurisdictional action authority has given you the notice and procedure.
Yes.
This is we have already said.
Yeah, WPC number 21,961 of 2021.
The assessment order.
It's really means the jurisdictional action authority has given you the procedure.
Well.
Instead of baseless, you have not followed the baseless assessments rule. Is it the fact?
Madam, this matter is pending. The similar matter is
Yeah.
pending.
That is what I am asking you.
Yes, sir. I have the instruction. I have asked the department. I have not yet received any instruction regarding that.
This what.
Who has passed the assessment order?
That's called the faceless,
Faceless assessing officer.
So, how this is relative? In those matters, it was not the faceless manner it was done.
Last
It was
the question, whether the assessment order is passed by jurisdictional action officer or the,
Then the assessment order has been passed by the faceless assessing officer.
then, so where is the problem?
He wanted as 148 proceeding, everything.
I'm not seeing.
Sir, you should know it was a jurisdictional officer who assumed the jurisdiction and issued a notice and did it not in a faceless manner.
Right.
Then we said that once the section 151A, I believe, that provides for a faceless assessment to be done. If how can a jurisdiction and assessing officer assume the jurisdiction? It cannot. It has to be done in that mandate. Here it has been done by a faceless man.
Yes.
So this is distinct from the other matter.
Right.
What? My lord.
This is my.
What? Then, sir, if there is a avenue or a remedy by way of an appeal before the authority, you go there and file an appeal. You are still within time. You are still within time.
Identical facts, I have filed the judgment of the Bombay High Court.
Maybe Bombay High Court may have a persuasive value, but
Identical fact, which has SLP against the revenue has been dismissed, both are merit and limitation.
no, that is there. There's no difficulty. They have exercised the power. We think that we should go for appeal. Go there and convince the authority. Convince the authority.
Notice also, the notice under section 148.
I understand, sir.
There
I understand you can take that plea before the appellate authority.
is a difficulty. The appellate authority is the commission of appeal.
So
But the notice, the approval for the notice under section 148 has been given by the administrative commission, who is the senior. He cannot vacate this notice. Unity appeal cannot vacate the notice under section 148.
It is not a notice, it is the order.
I have challenged unless the notice is valid, statutory provisions are there for issue notice under section 148 capital A. The four conditions prescribed under section 148A has not been satisfied by the judicial assisting officer while issuing notice under section 148.
It's an order passed by the assistant officer of the section.
Both the notice under section 140, there is a judicial error, as well as the order under section 147, which is under section 144B. So there is a judicial error.
Yes.
I don't know 10.
6 months.
So that
Getting a
will apply.
refund, that will not apply. That will not apply. This is the judgment, but whether it pertains a character of a pre-deposit, I think that has not been gone into. In this,
See that here.
if you read this judgment, it does not talk about.
My lords.
Go before the authority. You take all these fees before the authority, I believe that would be a timeline we will get.
My lords, on the issue of unjust enrichment, my lords, that issue could not come in the play.
No, that we can't.
My lord, the reason is that after adjudication, I've paid it from my own sources. There's no question of passing it on to the buyers.
Unjust enrichment.
Then that is
11B.
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 11B I'm looking at. Which one? Subsection 1, 2, 3, 4. I find only has not passed on to him to any other person. That's.
But that is the determining factor. If it is passed on,
Unjust enrichment, I do not find there is any concept of this.
with all due respect, my lord,
My
if
lord,
it is
if I-
passed on, and
If
again
I
they will,
pass it on to some other agency or some other person or to the,
and again will get
My-
a refund, that is on this. That is. If it is passed on, again he will get the refund. That is on this. That is the only thing. And that is the only difference between both these refund
No,
provisions.
no, I understand. I think now that proviso is added subsequently because of all those judgments, Mafatlan and all, everything.
my lords.
There has been amendment by virtue of a proviso being inserted, says that the period of 1 year shall not apply in a case where the entire deposit is made under protest. So the period has been taken away. Second proviso to subsection 1.
My lords.
It says provided further
Yes,
that the
1 year.
limitation of 1 year shall not apply, whereas duty or interest, if any paid on such duty, has been paid under protest. And this is under protest, there is no difficulty.
difficulty.
They can't say it. The thing is, the only thing is passed on to a third party, any interest. Whether timeline has to be fixed. It's better to say. Because it's a gray. Gray.
But could your lordship decide this, my lords? If I accountant lordship decide this, issue totally, because whether it will be a pre-deposit or
Again,
not,
my lord, that
the authority
actual
will not be
aspects
able
are
to
there,
decide.
my lord.
Lords,
Whether
whether it will be a pre-deposit or not, the authority will not be able to decide.
No, my lord, whether it is, that is authority cannot be, but on the face of it, my lord, what my submission is, my lord, it is under protest. No redeposit can be deposited under protest.
This is what he wanted the decision to come
My lord.
So, my lord,
by the court. He wanted that there is no decision which is coming as of now.
yes,
So what would happen to those deposits which are made under protest
you will get back.
before filing the appeal?
before filing an appeal, what would be the character of that particular deposit? Will it be a pre-deposit
No, my lord.
for an appeal, or it is a deposit which he is entitled to refund, provided
May
he has not passed on that interest to any third party.
I take your lordship to section 85 of the service tax? What is the intention behind this deposit? That is only reduction. He will get a reduction in the penalty, and that is 85 of the service tax.
With folded hand, I am just reminding you of the thing. When you talk about the penalty 15 times, when the penalty would be attractive. When a person who is liable to pay has not paid it, then he is liable to
My lord, I
pay the penalty, or he must be exposed to penalty.
I bow down.
Here the entire claim was negative, gone,
It was
because you have initiated a proceeding beyond the limitation
yes.
period. So once there is no proceeding, then there cannot be
No
any
penalty.
demand in vacuum.
No, my lord. I
There cannot be any demand in vacuum. If there is no demand in vacuum, there is no liability. If there is no liability, question of penalty does not arise.
my lord.
This is what I wanted. He says that whether this deposit can be termed as a pre-deposit or under section 35(1) or 35, then 35 FF will come. You are saying no, the deposit is independent to a filing of an appeal under section 35, and therefore 11B will be attracted. He wanted a decision to be taken.
Not the,
What would be the character of
not the
this?
authority to whom your lordships are.
The
sending
intention
back.
has to
You will
be
not be
clear.
able to decide that.
There may be some records which are required to be gone into when they file a regular appeal before the Sestat, and they emerge successful therefrom. Sestat says it's time bar, because this order originated from a refund. So in that, whether it was treated as a pre-deposit, how the Sestat treated this amount, there must be a reflection, because he has not filed an application for stay, because there cannot be any
Not, sir,
recovery.
without any demand being paid, the sestat would not have admitted my appeal.
There must be some order.
My lords.
So these orders are also very important before us. Bring those. If in that proceeding there is some reflection of the pre-deposit, then definitely
Yes, my lord.
he is entitled. You can't go beyond that. You have not also
No, but
included
I've not
that.
made my pleadings, sir. I've not made my pleadings, sir.
You have not consulted that record also.
My lords.
You should have. If there is any reflection,
Yes, my lords.
that will clinch an issue.
Yes, my lord.
When you will complete the pleading, tell us.
2 weeks time.
2 weeks. You want to rejoin that, you will file bringing those records.
Lords.
Let it be done.
January. 8th January.
Come in January.
Okay.
8th January.
Please consult those documents.
Yes, ma'am.
Which we think may throw some light on
Okay.
in your favor.
Lords. Lords, I'll try to solve my points.
That report of
My lord.
must go.
And record I will.
There was latches from both the sides, Your Lordship, in that case. Your Lordship, that case, when that case was pending, Your Lordship, and immediately was filed another appeal, Your Lordship. So that appeal has been disposed of. But that appeal was pending as such, Your Lordship. Your Lordship. So Your Lordship may kindly pass it.
Record. That is what I'm saying. Record that is pending.
Your Lordship may direct within a period of a stipulated period, Your Lordship may within 2 months.
Order will not stand.
Your Lordship, it is a peculiar case.
Sir.
Grateful, Your Lordship.
Yes.
DFT second application is similar.
Got that circular.
Your Lordship.
No, by what circular you have allotted a particular time period for finding nothing.
Fine.
What we are proposing is that since we have already extended the time of finding nothing.
Fine.
10% deposit which he is making,
Your Lordship.
that will be deemed to have been made. And let him find the appeal when his time will come. Unnecessarily, we will not keep this particular.
Your Lordship.
This don't get to that.
Your Lordship. Your Lordship. And also,
Now I think they have started filing.
Your Lordship, in our state, a very nominal number has been filed. Your Lordship. Your Lordship.
The filing has come.
Your Lordship.
Okay.
Your Lordship.
What?
So latest by June.
And give all those numbers of the cases.
The batch.
That was
That also.
that was
Your Lordship.
unnecessarily smooth, this will be a lead thing.
Right.
Also, matter will come and then will dispose of.
Your Lordship.
The list one after another will dispose of.
Your Lordship. Yeah.
12 miles.
Your Lordship.
Item 12.
Thank
Reassessment proceeding will not, reassessment proceeding will not, followed by notice under section 148 of your act, will not in a faithless manner.
Can we have seen that it is to be done in a faceless manner? Then you are not.
When we have to receive the instruction, then we think so.
We are passing an interim order and the matter is pending before.
Right.
If
We'll
you can
take this.
come in this matter, government and structure say that it is to be done in this way, because this is the case where we have said that the business.
Yes.
And
Good.
you can't avoid it, that's a mandate.
Right. Lordship, sub item 7.
Yeah.
So, my lord, GST tribunal not functioning, so it's a law.
Disposing of them.
Yes, ma'am.
15 is I was charging the section 73(4)B madam issue. 73(4)B.
So that is matter is pending.
Yes, madam. Madam.
So I don't see that.
Item number 16.
Madam, 73(4)B, madam.
Yeah.
73(4)B, madam.
Say, yeah, red on the.
Item 17.
My lord, in absence of the GST tribunal, main item and all the, my lord.
All the item.
All the
And
sub.
also,
All.
also item 18.
Eight- 18 minutes non-constitutional. Non-constitution of GST appellate tribunal.
Is some item?
Sub-item is also same minutes.
Item 19.
Item 19, my lord. Cancellation of RC, my lord. RC can covered up matter.
Item 20.
And item 20, non-constitutional tribunal, my lord. Non-constitutional tribunal.
We are imposing on.
Item 21.
RC cancellation.
22. Number 22.
Has challenged the division order passed by the order passed by the Commission on Assessment 264, the Income Tax Act, just filed for modification of section for revision of the order passed under section 147, which has been, the assessment order has been made under section 147, and then for initiation of proceeding under section 148, the ITO has created a new pen of his own. And thereafter, he has raised the demand, including penalty proceeding, and thereafter,
And he challenged the order passed under section 264, revision order, madam. Here, annexure 1, madam.
But you are challenging an order of 29/5/2023 also. Then, 147 order.
along with the order passed by the Commissioner under section 264.
We have number 4.
Well,
So that is that 50/55.
Hello.
This is new number.
This is new number.
That means this is new number.
This is a new pen number.
The
Not
same.
duplicate. The duplicate, what we understand is,
That-
I think, I understand.
Hello.
Same number.
Same
But,
One is lost, another is issued.
No, not lost. He for
why you use the word duplicate?
the ITO has created the duplicate pen number.
Not duplicate.
No,
What?
new pen number.
Say that the.
Sorry, madam. Sorry. And what interesting,
Another what is issued to you.
that I have regularly filing return in my PAN number. Last 13 years return, actual copy I have enclosed.
They have not taken it because you have disclosed in your PAN and returns.
My lord.
They have not taken it.
Right.
They have.
And another thing is, for initiation of proceeding under section 148, the precondition for initiation of proceeding has not been fulfilled. It is clearly bad by limitation. So I have quoted the provision.
Madam, she has challenged that order passed under 264, revision order, where the associate, madam.
He say, you have created of your own a PAN number and you have proceeded to assess under 148. He has disclosed all this facts and figures while filing the return. Then in the PAN which he was issued
Madam.
by your department.
Yes,
So what is your answer?
My lord, I have not arrived at.
Maybe challenging the
Yes.
second order, but.
Which
The
is the old one, new one? I don't know.
The assessment is clearly.
No.
There will be one PAN number allotted to each assessment. No problem.
So that PAN number obviously, up to that issue, taking this Aadhaar.
My lord, that I mentioned, my lord. Without that authentication after 1/4/2017, no pen can be issued. I quoted that provision also. That is,
What is your answer?
My lord, I have to verify whether that PAN number, why that is. I will take the inspection.
that is rule 114.
Next week. Take this up.
I have filed a IAJ.
Next week, we will cover. Yes.
You have to, you also take instruction, you have to be verbal impression, you have to address one of laws.
Non-constitutional tribunal. Non-constitutional tribunal. My lord.
No, this is a matter of the same assessor for different year. Issue is the same. That is 158 issued by the jurisdictional order of by the NFS minor. The same matter has already adjudicated by yours. It is pending before the authority for counter. Same issue. Yes.
Similar matter. So you take this. So then we're filing the counter.
Item 25.
And cancellation of the registration. Cancellation of the registration.
26.
26 73 4B. Sub item also same. Sub item, huh?
Item 27.
Sub item given into fifth.
I think 27 your lordship, non-constitutional of DSP tribunal. 28 also. 28 also.
29.
so this matter is. Matter relates to section 73 4B. my lord. Yes.
73 4B.
Item 31.
One is regarding the cancellation resolution. All.
Item 32.
Yeah,
Second selection.
Sub item one.
So item 1 is mine.
The last sub item, I have not received the copy. Copy has not been served to me. Last sub item, you know. You know, only the reason of cancellation. You can continue.
32 sub item 1 done.
So we want to, because for day we have to read one. Your lordship, and also, your lordship only 4 days.
Cannot be done.
Already your lordship has heard that's so minimal. Now until unless the case has been listed.
33 minutes regarding GST RC cancellation. All the matters.
The second, the sub-item 2 and 3, I am appearing. State government.
Yes, please. The first sub-item and yes, Mr. Sahu is appearing in that case.
It's at that time, 2 and 3 I am appearing.
Second and
Second and
third
third,
state is appearing. In first and fourth, Mr. Sahu is appearing.
Yes, give your appearance so that it will not be.
Order also.
The order them modified.
34 lawsuit is still RC cancelled.
Your
I know
lordship,
that-
34.
Sub item 1 and maybe I have
The first matter.
the first matter. The second matter I may be committed.
No,
Sub item 1.
First matter,
Lordship, first
and 526. Who's appearing, Mr. Adilaj or me?
Lordship has 4 states.
First you give 33523. Yes. You don't know Mr. Miller. No problem. Now we are taking 28659.
My lord, I may permitted to withdraw. There has been some invert
no, it's a
errors in the petition. My lord, I will
Withdraw. Right? The three. 33280.
My lord, this is cancellation of registration.
Yes.
I'm
not
my lord, my learned senior. No,
Yes, what about
next matter, I am appearing.
No. Code object, code runs.
Yes.
Item 35.
Lordship, this is the your lordship can have annex of 15 your lordship. You have glanced the lordship. And if one page I want to throw me. Annex of 15, page 71 your lordship. Your lordship, this is the no, this is the circular. No, Millard, it's not a proceeding. Millard, this has been issued to define the Millard, the proper officers and the monetary limit, page 71. In view of the section 2, subsection 91 of the GST Act, there your lordship, your lordship kindly have the paragraph 5, page 72, relevant your lordship. No. May I permit to place your lordship? Where is the optimal distance? Related to issue. Yes, sir. So-called notice.
The officer mentioned in column 2.
Is-
Column 2 is
Column 2, your lordship, this next page 73, Millard.
yes, column 2 is the function of the proper and decision of the because only from 73 and section 20 up to the monetary limit
Yes,
in column 3, 4, 5.
your lordship. Your lordship,
So they are segregated on a pecuniary basis.
this is so because the 29 provides as per the jurisdiction. Millard, the year Millard serial number 1, the superintending of central tax only empowered to
Only up to 20 lakhs.
10 lakhs, your lordship.
Huh?
10 lakhs, your lordship.
10 lakhs in case of a.
Not exceeding rupees. Serial number 1.
This is under.
74, 73. Both are empowered, Millard, in view of the notification.
That was the relation to wrongly embedded and utilized.
No, sorry, Millard. That serial number 2, column number 3, your lordship. Thanks.
Column number 3 is that if it is not due or short paid or erroneously refunded or input tax credit has been wrongly availed or used that. Which invites a show cause notice says 10 lakhs. But in column 4 it says that
Is related to CGST, Millard. ISGST. IGST.
this is not IBS.
Your lordship. Here is CGST, Millard. My humble contention with your lordships. Lordship, the impugn, your lordship, the so-called issued under a demand from so-called issued, Millard, beyond the Millard monetary limit, your lordship. Page 11.
It is issued by a superintendent.
Yes, your lordship.
Yes.
Yes.
What do you have to say, sir? Is it still in vogue or it has been superseded or no?
No, I have to take it's just a 1 week time.
Yes.
Wait,
Take this.
Millard, today they fixed for hearing 5 PM hearing Kendrapada. Millard, my
You
not to take.
It's not, he will ask for an adjournment.
That may be option.
What?
Send one mail. Send one mail.
I'll
Send one mail.
Okay, hi.
Next.
Oblige.
On 36.
But so that is the RC calculation.
I with regard to classification of the goods under question, your lordships. The goods under question is the potato chips, your lordships. Whether the potato chips is a classifiable under
Potato chips.
find out.
Yes.
Whether the potato chips are classifiable under the processed vegetable falling under entry serial number 2 or not, or under the
Potato chips is the right one or a company or is it the raw?
it is a pride one minus.
Right one.
I have purchased potatoes from PepsiCo Holding India Limited. I have purchased the potato chips from PepsiCo Holding India Limited on payment of tax at the rate of 4% and also effected sales are at the tax of 4%, treating it a processed vegetable falling under entry serial number 2 of Schedule B, your lordships. And the tribunal held that it is a residual entry falling under subject tax at the rate of 12.5%, your lordships.
Where is the
Order, my lords.
is 24?
24 is the order, my lords. And the relevant part of the order, you know.
Seconds later,
Grateful. Grateful.
Very interesting. Yes. The potato, please.
English,
And serial number 2 of
English, and
talks about all process
all process
or preserved goods.
or preserved foods may not be applicable here. English, English,
I'm coming.
man,
All preserved foods. Vegetable,
English,
including sauce, puree,
English,
food jam, jelly, pickles, fruit swap, paste, fruit drink, and fruit juices, whether in a sealed container or otherwise. Now the question is, please go by attention. I do not want to support this thing. Because once you use the sauce, it involves several ingredients to be included.
addition, English,
If you say the puree, it
Well,
involves.
that's-
Ingredients are not.
the finding of the tribunal rules.
So it gives you a pickle more. Many spices are used, many things are used in the pickle. The fruitish cost, everything. Now, processed or preserved fruits or and vegetables. Now, so far as the potato chips are concerned, no doubt. Slicings are done. This washing is one of the ingredients in every vegetable you have to wash it. You can't put it in this. So it does not really come under that. But it's to be fried, it has to be fried in a medium. Maybe an oil, maybe some other thing. You have to fry it. And then add some kind of the,
Salt,
I would say the taste enhancer,
English,
maybe salt, maybe some kind of the spices or something like that may be used for that. Does it lose the character of a vegetable because potato remains the same characteristics? Only thing is enhancing the palates. Is enhancing the products.
English,
Suppose a slice of apple in a sugar syrup to enhance sweetness.
English,
Does it lose the character?
Said that potato chips in the grandmothers and raised and making source to but consider as a global thing. As process is but not in this is a good.
That is what I'm just thinking of. When you put all these categories into one entry, then where the filters you are using, the beauty you are using, and what you the was, it should not lose its character here. But there is another aspect which I am thinking. If it talks about the vegetable or the process, then in that event you will be able to make a kind of vegetables to be served or to be tossed on something. But potato chips you can't toss it. You can't prepare any vegetables. I need the sabji.
English.
But
Actually, the intention of legislature, I think, like that, English. Only that process. No,
But I think a stronger side is Your Lordship, including all these things into one category, Mr. Nath.
Your Lordship, may I admit this question of law.
Now the household.
Potatoes, Your Lordship, nowadays.
Like a pickle.
Your Lordship.
Is there?
Actually, hit the lamp. What my Lord has said.
Uh-huh.
39, sir.
Maybe. You're not people. Oh, looks very case. Payment is also silent.
I'm not hearing a bit of the.
Here, it pays 71 is also there as well. You know what happens? The petitioner is the wife of the husband of the petitioner was taken loan from the bank, the investment bank, for
Which bank?
investment
The bank.
Yes. Purchase a truck, your person. Truck.
Sure.
Mine. But what happened? Meanwhile, the husband was died in the year of 2019. And after the getting from the loan from the bank, the husband was died. As the petitioner was the guarantor of this loan, she will pay. She has pay the all the installment
Remaining whatever the
EMI amount.
As a guarantor.
Mine, as the guarantor, you was paid EMI. And meanwhile, what happened? Out of 71 EMI, the petitioner has already paid 52 EMI and 14 EMI has been given. So meanwhile, what the present petitioner has proposed to bank for an OTS plan. As he was a digital lady and the income from the
What the bank says.
the bank my lord did not accept the OTS plan, your lordship, and
Seize the vehicle.
my lord,
Vehicle is seized.
no, vehicle is on another place, your lordship, from another place, not seized by the bank, your lordship.
Not in your place, in your custody also.
Is my custody, but as we are not able to pay the EMI amount, your lordship, as
So
per
you have kept it high. How much is the total amount?
my lord, the total amount, the loan amount was 70 lakhs.
52 installment.
Mine.
70 out of 17 installment. 31.
Mine.
How much is the remaining amount?
My lord,
Installment.
my lord, 17 lakhs was the loan amount.
Weighted monthly installment. What was the amount of each month you have to pay?
My lord, 6 lakhs from what you my lord.
Due.
My we propose for the 4 lakh that we would make a OTS amount that the petition is ready to pay the 4 lakhs amount. And that proposal
And the remaining amount?
My lord, that I am coming to the point. My lord, 17 lakhs was the loan amount. And in the 58 installment, the petitioner had already paid 22 lakhs 18,000 already paid, your lordship.
What comes out from the budget signatures observation that the outstanding is 5 lakh 80.
Mine.
You are saying that it is 6 lakhs.
6 lakh, my lord.
He had already given you to pay the installments. I think he has gone beyond the jurisdiction and the powers.
That's true, my lord. My humble
They
submission.
have not come forward. What more? How can we say that? Liquidated.
My lord, the petition was deducted lady, my lord. There was no income.
Maybe. You can't. My view is even stronger than. My view is very strong. I go by a order of law. The lead jurisdiction and this order very difficult. So in the appeal, then we'll have to.
That other portion for exchange. With appeal, we have to see the legality. Then you know. There's no and line of judgments thereafter. 2022, then 2024, legal judgments.
What to do?
It is better you for extension you can.
Right.
That is
Exactly.
scope, perhaps.
My lord, liberty.
But liberty. We will grant you a liberty.
I will approve for extension.
Always saying that we are not advisory jurisdiction, but we can do a right. Let us.
Well, a memo.
Mine.
Item 40.
Made. Appellant is highly satisfied. Appeal against the order, against the judgment and order projected 18/9/2025.
I don't know. There is no agreement.
Yes.
Yes. Or this person is different person. You are.
Yes, let's see. Yes.
Same person.
Yes, same person. The matter with the appellant. No, appellant, the fact of this. That.
Yes.
Yes. The fact of the case, Lordship, the appellant was convicted in a vigilance case and dismissed from his service. And the before the criminal appeal before this honorable court was acted, and state government revoked the dismissal and reinstated the service. And after that, his promotion and his coronation. I pray the period from dismissal is the actual period from the dismissal, the period from
You were working in this department of the government?
revenue department, OS officer, when you're this. The honorable, this honorable court has already passed the similar order, similar judgment in this my lord.
And madam, he has cited certain judgments and says the difficulty is that yes, no doubt about it, that you were dismissed from service.
Yes,
You challenged that order of dismissal and ultimately succeeded.
yes,
Reinstatement was done.
yes.
But there was a loss of a considerable period in between
Only
the
period.
order of dismissal and reinstatement.
Reinstate.
Now, at the time when the order of dismissal was set aside, the court has two options, that's the discretion. Either to direct the entire back wages to be paid, or they say they no back wages. If there was no direction, can you claim a back wages?
That should be minor's judgment
I
is
think-
there. Minor's judgment is
Which judgment?
there.
There are judgments, I say, but it is a discretion. Can a second round of litigation for this purpose rise? Court can, there is no fetter. When order of dismissal or termination from service is set aside,
Yes,
the court may direct, it's a discretion. But if the court does not or did not provide, can a second round of litigation for such purposes maintainable?
let me know second round. Second.
This is a second round of litigation.
Then second round.
You were successful.
I have filed a representation, rejection of my representation.
I have a very strong aversion to a representation theory. You cannot resurrect the dead wood by way of a representation. The question is very simple. You challenge the order of termination up to this court.
Yes.
It was allowed.
And,
So read come to an end. Read petition. No pending. Court did not pass an order for all the back salaries or back wages to be given to you. you were reinstated, you continued, attend superannuation. After superannuation, you have filed a writ petition that you cannot be denied the salary for that period. I am asking you, is the second writ petition maintainable? Why not hid by order 2, rule 2? You ought to have paid for back salary in the first writ petition. That relief was available to you. Can you?
That part you should be admitted, maybe admitted, you should that part.
But the question is against you and you wanted an admission.
My senior will be,
Bring the senior.
today is the senior, he is available.
Yes. Somebody is available. Next week,
Yes,
available. Once you took a chance, that you should be ready to argue everything. If your senior is there, then take a rest. This time we are giving, but I have a very strong reservation. If you start, you should finish. Anyhow,
Item 41.
The matter was it's an order dated 13/1/25. They start time that they will give a report with regard to the OP number 5 is operating ward number 42 or 43.
My lords, I've received instructions, my lords.
Take
A request. My lords, I've received instruction. My request, Mr. Saswat Das, to hand over the instructions, my lords. The inquiry has been done, my lords, in this matter.
no, it is still continuing.
Yes.
My lords, the main
What has
allegation.
happened? What has happened on 20th of November?
That information, my lords, I have not been able to receive it till now, my lords. If it may be taken up next week, my lords, I have already told the department to get all
Let them
the.
complete because this has been done
Yes, sir.
and this is going on. I believe that you were also called for a hearing.
No, Lord, I have not been.
Opposite party number 5 was called for a hearing.
Petition was not.
Here I am entering appearance for the OP number 5.
Yes. Right. The instant writ petition. Yes, please. Let's call the next.
Item
40
42.
or 43.
42.
Section 73
Yes, adjourn Senada.
Item 43.
Refund has not been granted in spite of he has submitted refund application in due time. Since 19 it has been pending. He has not paid my refund amount. And I have issued any order, nothing.
In this case, I've been instructed to get instruction from the department. I got the instruction in general. This application was rejected on 19/9/2019.
Application?
Was rejected. A refund application due to want of document. Also. But
They supplied that order.
Somehow that order, which has been annexed in the detailed status, detailed sold as annexure 3.
Yes.
It has been clearly written that it has been only two lines rejection section, refund sanction order and rejection order in RB6. It has been mentioned. And as per our departmental queries, this refund application was rejected due to non-submission of document, wanting document. But the Lordship, we have also raised this question before the technical. This order is not been uploaded. It has been uploaded, but it not been shown in the GST portal.
Correct.
So for that reason, we have also raised a question, and they are helpless to give give a correction. My humble request, Lordship, if you court may direct, they can apply for another application, and accordingly that.
But that will be a time bar. This is relating to what? I do not know. Is there any time limit within which the application? So what would happen to a time bar?
Is of the year 2019. By now, much water has been.
So now he will be again put into trouble.
I have been instructed that if a direction will be given by the court and they will
How can we?
there is a possible that they can process the thing.
This cannot be. The order was never uploaded. It was not communicated. Then will have to. Status will not do because you have to serve the copy. Then it reminds me of that judgment of the apex court that the order is kept in the cupboard and not communicated or sees the light of the day. Then this is no order in the eye of law. Then we have to say in that line that it was never communicated. It was simply kept there. Not even uploaded on the portal, which your section 1, what is the one? What ordained? There are various methods.
It was processed, but somehow from technical reason,
whatever it is not there, then it can't be.
We have also technical application.
We will say that this order cannot be. You'll have to. If it is there, it is no order in the eye of law, and then you process that application and decide. What did you give some instructions? Paragraph 3. Paragraph 3.
And that's true, Lordship, they have paid the amount in IGST also and CGST also, which has been confirmed in para 4 and 5 also, Lordship.
True. That is there. Yes. Cite a judgment. That if it is not communicated, not something, then why we will find for you?
Something next week I will give you. If he wants to release my amount.
Your Lordships, the next matter, Your Lordship, referring to Harla's
No,
case.
is not pending. They say that they have disposed of
They have a
and they have rejected your refund application. But the difficulty is the order is neither with them, nothing. Where the order is, nobody knows. And it is admitted fact that they have not uploaded also. Nor they can show that it was sent to you by post or something like that. So in that situation, we have to think whether this will be a good order in the eye of law or not. It's coming the next week. We have to find.
Item number 44.
May it please Your Lordships.
Yes.
Oh. Lordship, in the earlier matter, Lordship referring to State of Rajasthan as Harla's case. Order kept in the cupboard is no service. The Supreme Court.
Kept in the cupboard.
Harla's case, Harla's case, the Lordship. Harla's case.
Yes, yes.
State of Rajasthan was Harla's case.
Yes, what is this matter?
Lordships, I am appearing for the assessee in this matter along with Abhijit Agarwal. Lordships, this is the case, Lordships, where despite the Lordship's judgment own case, that as far as export duty on iron ore fines are concerned, you must take the wet weight.
That is a wet, that is a dry weight or a wet weight. So we have already delivered my
Lordship,
own.
In the present case, Lordship, Commissioner, Your Lordship, in this very matter, gave the direction, you go by the wet weight because customs to be presented on the form in which it is exported. In the present case, he says, some of the documents presented by you are not authentic. Therefore, I will take the dry weight.
How can?
What we say is,
how can it be?
Law cannot change. For not authentic, whatever consequences may be there, that the tax rate will be the same. One. Secondly, Your Lordships, my document they say is not to be relied upon, but they drew samples and sent to their chemical research laboratory, which is their own laboratory. That report, Your Lordships, is in my favor. Consciously and deliberately, they don't refer to it in the show cause or order. In my reply, I say, go by that report. Then, based on wet weight, I am less than 58. So, the Commissioner's order, Your Lordships, notes my objection, doesn't deal with it. So, our first submission, Lordship, this is a major demand is on this question of law. Okay. So, Commissioner order confirming over 400 crores of duty on this ground, Your Lordships, that is unsustainable. The second issue, that's a separate issue, Your Lordship, that is our submission is Commissioner has not dealt with our reply at all. And that part should go back to the Commissioner for re-adjudication. But the first issue is this, subject to what my learned friend says, Your Lordships. If he wants to file a reply or whatever it is.
Specific intelligence was received by the from DRI. And then a detailed investigation was taken up, show cause notice was issued, and then they came before this court for order was passed, where lawyers directed that for the said purpose, the petitioner is therefore directed to appear before the concerned authority along with copy of this order on or before 25th July. On the date of such appearance, the authority may proceed to finalize the provisional assessment forthwith or may adjourn the proceeding for a future date as he deems appropriate. However, after affording a reasonable opportunity of hearing, he shall conclude the proceeding. It is further directed that while petitioner assistance shall not be granted unnecessary adjournments, and thereafter they appeared, they produced documents, and after that thorough investigation, as per the investigation.
But what has been held? Is it not contrary to the order?
If my learned friend says they have taken the wet weight, I will withdraw. If he says, if he has taken dry weight, Your Lordships.
WMT and DMT method.
Look at it. He is happy with the dry weight.
So he has taken the dry weight, whereas Your Lordship says take the wet weight.
Yes.
So that's the core point. There's no, I have seen the petition.
We have already decided that it should be the
Lordship.
weight that should be there.
Some factual issues are there.
Uh,
So that should be taken care of at the upper statements. That's my humble submission. There are factual issues. They have also considered in this repetition. Point number 10, 11, and 12. That cannot be taken care of at this stage here. That is only factual issue. And so far as the OIO is concerned, that is appealable. And recently, Supreme Court has issued part on judgment. May I submit that?
What?
So that alternative remedy is available.
Oh, that is the discretion. That's the latest judgment also says,
Yes,
not compulsion.
not compulsion. That's
So there is no difficulty. But what about that judgment of dry weight and a weight weight?
specific point, my lords, remand that matter on the specific one so that it can be taken care of only that WMP and DMP issue.
We have already decided what more. What more? We have already decided. You have gone for a dry weight. We said no, it should be wet weight. So what the authorities will decide?
What we have directed once.
Yes, yes,
Earlier round
that
of-
direction.
In earlier round of litigation,
Yes, ma'am.
we have directed, you have not added to, then what shall we do? Again, another read,
So far as
why should we? Successive reads, should we?
no,
If your authority is not complying with.
No.
Then,
since there is-
And that was also the judgment which relies the Supreme Court judgment also.
yes, 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 yes. That is.
So in that event, how can an authority defy and then take an independent decision?
the authority appears to have not taken care of paragraph 8.
Yes.
She has only taken care of 8.1 and 8.2.
Yes.
So main portion,
Is conveniently ignored, Your Lordship, not oversight, conveniently.
paragraph 8 is very clear.
Yes.
So why should we issue further direction?
Yes.
Because entire investigation is futile if this one goes. Only that issue I consider that, yes, that is a,
Paragraph 13,
yes,
we have relied on this judgment.
yes.
Recap, recent,
Recent.
paragraph 13. Has the ruling universal application?
No.
Paragraph 13 makes it clear. That goes against you.
Is there. But at page, point number 10, there. That is clearly observed. Yeah, please. Yes.
Orders after 2 weeks.
Actually, I have to take only one small submission, which is in revenue's favor. There is another demand about 40 crores raised in this very case. In those cases, the lordships, it is above 58%. We have paid the tax also. They say value declared by you is incorrect. Value should be higher. That's a pure question of fact. I cannot trouble your lordship. But on that, your lordship, I filed my objection, detailed reasons. Commissioner doesn't deal with any one line. So therefore, our submission would be, lordship. On the first point, our submission would be, lordships, the impugned order should be quashed. On the second point, because he has not dealt with any of my objection, even cursorily, matter may be restored back to the file of the commissioner for unconnected issue. I have made a small synopsis, your lordship. My colleague will hand over to your lordships.
I'm filing my written submission.
You want to file? There's a
11th December.
Lordship, on the alternate remedy, only one line, your lordships.
Yes,
Way
yes.
back in 1966, Supreme Court held, when the authority's order is contrary to law laid down by your lordships, the writ will be maintainable. Obviously, East India Commercial, your lordships.
The parties.
Item 45.
Item 45, I play for him. In item 45, I play for him. Mr. Gopinath Krishna is not to be present.
Who?
Mr. Gopinath Krishna.
Who is the other side? What do you say? Relating to.
Read of
When we have read of him.
Send down the map. Item 46.
There is no formal, there is a formal delay condonation which has been raised by the stamp reporter. In a contempt matter, which is this lordship, this petitioners have been greatly under very distressed conditions. They worked for 25 years under the State Bank of India. Previously, much earlier, they had filed a writ application. That writ application annexed to
more than 1 year has elapsed. Why you filed a condonation?
Because the condonation of delay, when formally the stamp reporter has reported, it is not coming within the ambit of section 20 of the Contempts of Courts Act. Your lordship, I kindly have it's a continuing cause of action, page 16 to 18. I will take a refer your lordship to the judgment for which the contempt has been committed. So that's a short judgment. Page, your lordship, I kindly say page 16 to 18. Page 18, can I take your lordship to? Heard in view of our order dated 24/7/2007 passed in WPC number so and so, no further order is required to be passed in this case. We dispose of the writ petition in terms of our order dated 24/7/2007 passed in the aforesaid writ application. We make it clear that the case of the petitioner shall be considered for regularization if any vacancy arises in the future, and so long the work is available, the petitioner shall be allowed to continue to work as such.
and shall not be substituted by any fresh hand. And the petitioner shall be paid remuneration as applicable under the Minimum Wages Act. These persons were working with submenial staff, class 4 employees.
The volition has taken place.
Your Lordship may kindly have a glance at Annexure 1. They have served me. What happened, my lords? I went on a single writ petition for regularization. Since this is a 98 order, they did not regularize my services. That regularization order, which has attained finality, this order has attained finality, has not been disturbed. In the single judge, that is Annexure 5, page 2342, your Lordship may kindly have a glance, wherein which is writ appeal has been preferred and which has been admitted by your Lordship also.
To whom?
My lord?
I will serve.
This is State Bank of India notice to go to SBI. State Bank of India.
This is what is there.
Contempt.
It has to be given.
Notice has to be served upon them, unless your Lordship directs.
Notice 3 weeks. Yes.
Item 47.
When a delay could be first specific date when it would go and delay.
Both has to be notice on both. Application as well as.
So I filed an IA for stay. They have taken this extreme stay. Your Honor, kindly have that stay.
Order 41, Rule 3, capital A, sub Rule 3.
Once a writ appeal is pending, your
Yes.
Lordship,
It's not a pending.
writ appeal, your Lordship may kindly have a.
Because unless it is condoned, it is not regularized. You can't say the writ appeal is pending.
No, I have filed a writ appeal against the judgment, which your Lordship has admitted, that is WA number 1274 of 2025. That was for temporary pay, and for regularization, that is WA 1310 of
You can't pass an
2025.
entry order of state.
Well, your
Without
Lordship,
Section 5 being allowed.
your Lordship may kindly have a glance at Annexure 5, space 23 to 42.
Rule 3A, show it to him, and sub Rule 3 is the main.
See, Article 215 overrides.
I am. 226 does not mean that all the procedural aspects has to be thrown away.
Your Lordship has the jurisdiction under Article 215.
Sir, that is again, then Pallav Seth's judgment of the Supreme Court you read. This argument was advanced that there cannot be any period of limitation. Even a contempt of courts act does not apply because this power to contempt is provided under Article 215 of the Constitution. So the court can punish any person who purged or who have done some violation.
My lord.
Negative is guided by the Contempt of Courts Act, as Section 20 was made applicable. Limitation was invited and says that you come.
Well, there is a small gray area whether Section
Nothing
20 will
clear.
come to the High Court.
I tell you,
Is
the
applicable to the High Court.
The
Whether
Calcutta High
Section
Court
20
view, the Calcutta High Court view was in 1993-94, the judgment delivered by Justice Bhagavati Prasad Banerjee, taking 200 an article as the front runner, says that there cannot be any period of limitation for the contempt
Yes,
of
well,
the High Court.
Our High Court
The
view-
Contempt of Courts Act does not lie to a district judge or district courts. It's only applicable to the High Court or the Supreme Court. They can't, under Section 10, if they found any contempt, they have to refer the matter to a High Court. High Court will initiate a contempt proceeding or a contempt before the district court. So that is why it was and in the Supreme Court, I think Justice Ruma Pal was a party to the bench. Pallav Seth. It says that no limitation, Section 20.
is
So
applicable.
easily is then go, we can't go.
That notice has to
Anyhow.
go. Notice has to go.
Every rate rule says provisions relating to the code of simplicity or will apply mutatis mutandis to the rate proceedings.
So is not pressing. You are not pressing your IA 425, 2024.
Oh, then also give.
So the IA is for amendment, that
So
amendment.
you are not pressing.
Right, yes.
Anyhow,
That amendment of the constitution.
is a more academic, come ready with whether an application for condonation lies in a contempt proceeding.
And one time
If
2025.
that
Well,
also,
here I will just take your lordship to one thing, that the judgment of this court has to be implemented.
sir, I am again saying, when you have taken out an application for condonation or delay in filing in a contempt application or a proceeding, whether section 5 lies, you also come ready.
Sir, one time 2025, para 2, this court.
With this given up of judgment, I think he should go through that.
He knows.
He knows it.
Very good. His service expert.
Are you not aware of Justice Ruapa's judgment of this?
No, well, so I was also delving at a particular
Sir,
point that for 1 year we didn't.
Where you held,
Yes.
I don't think we should.
Yes, but
Tell you
the
that-
question is, my lord, every case.
The question
it will be
again,
judged on the facts
the
and-
larger question again, I'm saying, larger question again. Is the contempt proceeding supplemental or incidental to the main proceeding, or it is an independent proceeding? If it is an independent proceeding, whether section 5 lies. Come. I give you a lead. In the next week. No stay.
But can I pray, your lordship may take up along with WS?
For 3 weeks, that's 3 weeks, let it come, yes. Next week.
2 weeks, my lord.
Item 47.
47, I am for the respondent, just now received the copy of the writ appeal. So I pray
Delay
one
of
would
80 days. I have short copy on them.
Sir.
one would appeal.
Next week, come ready, sir.
Item 48.
There is a delay of 690. Always, nobody has.
Item 48, I am the petitioner, my lords.
It's 3 weeks. 3 weeks.
Item 49.
Please, your lordship.
Yes, sir.
My lords, here, I am petitioner in this
What is this
writ petition.
For the inclusion of the two.
I am petitioner here, my lords, in item 49. I am there virtually. Lords, may I pray, this may be called along with WPC 7639 of 2022,
Why, sir?
which is pending. Lords, because here I have challenged a sale notice, my lords, whereby my OS shop, where, my lords, a direction was passed in WPC 7639 of 2022 that no coercive measure should be taken subject to my compliance with interim directions. I have complied with, which they are not acknowledging now in the counter. So if that writ petition is called and this matter is taken up next week along with that, my lords, it will be easier for your lordship to dispose of this application as well as my earlier application.
If start with this. If there those are disposed of, no, sir. No, sir.
No, it's not a disposed of.
Disposal.
If it's a disposed of matter, we will not tag those.
No, my lords, it's not disposed of. It's a pending matter, my lords.
It's pending.
7639 of 2022 is a pending matter.
You have stated here. IA was disposed of.
Yes, madam.
Yes.
It has been disposed.
Interim application was disposed of.
Main petition is still pending.
Just find out that main petition next week, if it is related, then you tag it, otherwise.
No, this arises out of that, my lords. So
Just
they are
let us
faults.
see, huh?
That's it.
Yes, fix, bring that on the next day, not with, just after. As a regular item number.
Well,
Yes, next week.
item 50.
Item 50, but the tag method may kindly include her movement, that order. The order date is 26 July 2000. This can be disposed of, Your Lordship, because against the first appeal order and this repetition has been admitted since tribunal is not there.
And they have also pleading that.
So we are now what has happened, they have already taken out a circular. In the circular, they have fixed a time gap, 3 months time for a particular, the assessment or assessment year.
First appeal order.
First appellate against the first appellate order. They say that anybody who is aggrieved by the first appellate order concerning this particular financial year or assessment year, he can file an appeal before the tribunal within that time.
The date of order.
So the tribunal is now becoming functional. So we are disposing of the matter, saying that 10% deposit you have already made or you have not made.
The first line of the order. Lordship, sorry.
They don't come next Thursday, Your Lordship.
Why? We are giving you a relief. That 10% order is there in this case.
Refund. Rejection of refund.
Oh, refund.
Your Lordship. With that matter, Your Lordship may kindly look into the order dated 20.
Anyhow, he is feeling an impediment. Senior is not here. I do not know.
Your
When? Next Thursday?
Lordship, 18.
No, next Thursday. Tell your senior to come. Who is your senior?
Lordship, Senior Advocate Mr. Ravi Raman.
Yes, let him come on next Thursday.
18th, Lordship.
No, can't.
18th is a Thursday, Your Lordship.
Thursday, 18th.
Item 51.
In this case, we need another 2 weeks time to file the complaint.
First time extension or first time or second time extension?
Second.
Pay cost. That would pay cost.
We have already been inspected, but this is a matter retrospective. Retrospective assessment. Here the exemption certificate.
Once
Trust.
registration
Charitable trust.
whatever
The
assessment
previous year,
given a
previous assessment year it applies.
Right.
Proviso.
Right.
So that.
You have two second provisos.
We had a very good case, Your Lordship.
Convince my brother, otherwise my view is second extension you'll have to pay cost. First extension we grant, second pay cost.
And since morning, I think they are waiting.
My lord, it's already covered by honorable appeals court decision.
Yes. Is up to you, sir. So last time there was a direction, 30th of October, the direction was given. We gave you a full time, 20. That was on 30th of October. So more than 27 days nearly was given to you. Pay something for good cause. It will not go to them. Don't worry. But it will go to a good cause. Yes.
This time let's give them a time. This time let's give a time. No.
Pay the amount so that it will be used for the upliftment of the street children. Or I can refer it to a juvenile homes to provide them some good Government run program, the juvenile, no difficulty. So government money is utilized for the government's good cause.
Actually, third time. This is third time. Second, virtual. This is third time.
This is third time.
No, sir.
In second case, it is both time.
First time we have constituted.
Acha.
Second time we have given writing something. Then this is
5,000, 5,000. You just 5,000, you give. We will extend the time by 2 weeks.
Let me take inspection from my.
Yes, then 25,000 rupees each. Yes, just put it so that we are simply adjourning. If they ask for extension next day, then or acceptance of the written counter affidavit on the next day will subject to. Just remind us. 25. Yes, call the next.
So next week.
Simple adjournment.
Next week.
Next week?
Next week.
Next week.
Both the cases.
Yes.
Item 52.
Yeah, let's say item 52 and I've already filed the contest. So let's say I am serving the copy.
Oh.
And yesterday, we filed.
Rejoinder in the meantime, next week, 2 weeks. 2 weeks. Rejoinder. Counter affidavit file, we accept it.
Interest order of problem. Lordship, I will be pardoned to make it very fully item 44, your Lordship have reserved it for judgment. Lordship have granted 1 week time to file the written submission. However, I filed it right now, but we wish to add few points in the judgments in that computation itself. So if that can be, we will also file it.
Come with that, there is nothing, we have simply recorded.
no, we are not reserved. for-
Yeah, let's.
All orders.
No. He wanted to take back.
Yes.
Then don't write that sentence that he has filed.
Yes.
Just say the parties are directed to file
Yes.
within 2